Afternoon, everyone. Thank you for joining us. My name is Eric Boughman. I am joined by my partner, Gary Forster, and this is the 5th installment of our webinar series for 2017 on the 11 Commandments of Asset Protection. And the title of this particular commandment and webinar is Choose the Terrain Wisely, Where You Plan Matters. And what we're going to talk about today is issues pertaining to jurisdiction and the choice of law when you are creating entities and trusts generally. And Gary, can you say hi to our audience?
Hi, hello. Thanks for joining us. This is called the conflicts of law and the comparison of law between different governments. I find this one of the most fascinating areas of law in general, even outside of asset protection. One of the reasons I became a lawyer, actually. People in most countries usually deal only with their country. They're not divided into states the way we are in the States. Are we ready to go?
I think we had a glitch. It says start broadcast. Webcam not detected. Currently, only staff can participate in the conference.
We might have a
If you can hear us, folks, we apologize. We may be having a technical issue here. All right, good afternoon, folks. We had a little technical glitch. We had gotten started, but apparently we realized we weren't broadcasting, so thank you for bringing that to our attention. My name is Eric Boughman, and I am joined today by my partner, Gary Forster. We're with the law firm of Forster, Boughman, and Lefkowitz, and today brings the 5th installment of our 2017 webinar series on the 11 Commandments of Asset Protection. And for the next 50 minutes or so, we will be discussing today's topic, which is titled Choose the Terrain Wisely, and Where You Plan Matters. And generally, we're going to be talking about issues involving jurisdiction and a choice of law, and what that really means is where you establish your trust or LLC or other entity and which law governs. So we'll dig into those issues throughout the next hour. And Gary, could you introduce yourself to the audience, please?
Hi, how are you? Happy you're attending. This is one of the more interesting, I find at least, areas of asset protection, and this idea of comparing and contrasting and even conflicting law in terms of determining which law applies to a particular document or transaction or trust arrangement. Is one of the reasons I went into law. I find it very fascinating. Most people are live in a country where they typically do business and live in that country and don't hardly deal with any other jurisdiction. In the States, we have really 50 jurisdictions, and then we have, of course, other countries. So we deal with the cross-border issue much more than in foreign jurisdictions. And you'll see that although we deal with the matter much more than the typical country, we haven't really handled it all that well. There are a lot of questions and issues associated with which law applies and how to plan on utilizing the most protective law, and we'll work through a lot of those issues. And if you have a question, I think there's a way to actually, through the broadcast, post a question, and we see that question and we'll address it immediately. You don't have to wait till the end or anything like that. And of course, we'll leave some time at the end for some questions.
All right. So with that, just an overview of what we'll talk about. We've already touched on it with a little bit of background on asset protection and the series in general, and then the considerations involving jurisdiction, choice of law, and we'll wrap up with a conclusion and some questions. And we'll begin just a little background, and some of this will be maybe somewhat repetitive for those who have joined us before. But when we talk about asset protection, we're talking about mechanisms to legally insulate assets from creditors by creating structures such as trusts and LLCs into which we transfer those assets. Gary does these both onshore and offshore. I get involved more in the litigation side of things and the analysis when there's potential adverse claims. We also talk about the use of exemptions in asset protection. Each state has unique exemptions. Florida, for instance, where we're located, has one of the broadest and most favorable statutory exemptions available, and that is the homestead protection. It's almost unlimited. And as we'll talk about as we go through today, picking where you form an LLC or a trust, keeping in mind that exemptions are generally going to be dictated by where you live, but where you form an LLC or a trust can have an impact on how well that vehicle holds up if it's eventually challenged. Moving on, we'll talk about first here is, when we're talking about picking a jurisdiction, some initial considerations. One, if you're going to use an LLC, an initial issue you need to deal with is whether that limited liability company will be a single member or multi-member company. And I'll let Gary explain that briefly, why that's important.
Sure. We've had a wave of cases over the last 8 to 10 years where LLC statutes have been established in all the 50 states. And the LLC is different from the corporation such that stock in a corporation is not protected at all. If someone's sued and the defendant suffers a judgment, whatever corporate stock the defendant owns is pretty much exposed to the creditor's claims. That wasn't true with partnerships, but partnerships have their own problems. So each of the states created the LLC, which limits the creditor claims to LLC equity. You're still not liable for what happens inside the LLC, but what the LLC does in general is if someone sues you and you own LLC equity, they can't reach the LLC equity. They can just lien the equity with what's called a charging order. So it's much more protective than a corporation. When someone, when a trial occurs or litigation occurs and someone suffers a judgment, the judge typically wants to enforce that judgment. Otherwise, the system breaks down somewhat. If we're doing litigation, if we can't collect against the defendant, it's kind of pointless. So that's we like that when it's pointless. So basically, you'll have a judge reach for remedies to benefit the creditor. So if the creditor wins the case, they want to be able to cause the debtor to pay the creditor. So what's happened is several years ago in Colorado, the idea that if someone owns an LLC as a single member, a sole owner, that the LLC protections don't apply. It's not in the statute, it's not really in any statute, but the idea was originally came from partnership law, where if a partner is sued, the idea of the protections on the equity of the defendant partner is that it's supposed to benefit the other partner, that the other partner really doesn't need to have a new partner at any time. So the offshoot of that is we're going to protect equity in partnerships. So if there's no partner, what's the point of protecting equity in these entities? This has nothing to do with the statute or the protections, but in my opinion, the court kind of reached out in bankruptcy and said, okay, well, there's no partner here, so this charging order protection doesn't apply. So that has made a tremendous inroad in bankruptcy, and then Florida ended up adopting the same policy a few years ago in a non-bankruptcy case, which spun the whole statute kind of into question, and the statute was completely rewritten because of that. And we result in Florida that the single member still is pretty much unprotected, although the multi-member is stronger. So when we look at the choice of law issue, and for instance, if you're a solo member in an LLC, which in general we're starting not to recommend at all, we definitely don't want to pick a jurisdiction that offers an LLC that's totally exposed. So the most basic type choice of law issue is, okay, I'm a single member, which state protects a single member? And several states actually have included in their LLC statute language that protects a single member. and then we're going to get into, okay, we've invoked the most basic aspect of the choice of law by using that statute. Let's say we use Delaware or Nevada. If we're in Florida, will that be respected? And we'll get into that in the future slides here.
And that kind of brings up another issue that we'll talk about a little bit throughout the webinar today, and that's the application of what's known as the Internal Affairs Doctrine. And the Internal Affairs Doctrine essentially says that internal governance issues relating to an LLC or a corporation, an entity formed under a particular state's law, and you know, just to back up a little bit here, make sure we're all on the same page. If you haven't been involved in the formation of a company, if you're sitting here in Florida or whatever state you're in, and you want to create an LLC, for instance, other states allow you to create an LLC under their state's law. And Delaware is very popular, Nevada is very popular. And so when you do that, you then are essentially subjecting some governance issues related to that entity to that state's law, and the statutes aren't the same state to state. So Florida law may, you know, if you don't have something spelled out in an operating agreement, Florida law may treat that differently than Delaware law would. And then there's certain matters that certain states' statutes find contrary to public policy. So you may have certain provisions, for instance, in an operating agreement, maybe restrictions on the right to seek a dissolution or restrictions on the right to seek a custodian or receiver that in one jurisdiction may be fine and in another jurisdiction may be found contrary to public policy and unenforceable. So when you select your entity, you're selecting which state you want to form it in, and you're also determining at that time that the internal governance of that entity is subject to that state's laws. So Gary, you want to add anything?
You think you are.
Yeah.
So the idea is, it's amazing that this stuff hasn't been fleshed out over the years. But for instance, Florida has a statute. It has an internal affairs statute. Most states have it, or they have it in the common law, which says that, you know, if I form a Delaware LLC, that basically that's a Delaware, I call it like a Delaware nickel. So that's a Delaware LLC. So the way that Delaware LLC operates is going to be governed by the Delaware LLC statute, right? And then, so I'm not forming a Florida nickel. So when I form that, now obviously if I do business with that LLC in Florida, I can be sued on my operation of my business just like anyone else doing business in Florida. The question becomes, though, if I'm sued and someone wants to take my LLC, is the charging order protection an internal affair? In other words, can I pick and choose which law is going to apply to me to protect my equity? The corporate lawyers say, of course. I mean, that's why we have different LLCs. The litigators say, well, wait a minute. You know, I need to get to that equity. You're doing business in Florida. I want to apply Florida law. Crazy enough, people have been successful on both sides. If you look, interestingly, if you look at the statutes, if you look at the Florida LLC statute, it talks about Florida LLCs. It'll say the LLC, it'll define, it's only Florida. But courts have actually applied that LLC statute to other LLCs outside of Florida to reach the equity. It's an interesting thing. It's really hard to completely control the judges. I think a lot of times there's some like a lack of understanding associated with the rulings. The law is in flux. It's very important when you make these decisions that you use someone who's familiar with what's going on.
Yeah, and let me point out too that, you know, Gary and I, by the way, one of the reasons we like doing this and doing it together is that there's issues that we sometimes disagree on, and we have, you know, raises interesting conversations. And as I say that, by the way, anybody who's listening, if you do have a question as we're going through, we're happy to address questions as we go along. So we'll monitor it. You can throw it into the little board there for the webinar, and we'll see the question and address that. But you know, this effect of the internal affairs doctrine as it pertains to third parties is an area where Gary and I may sometimes disagree. And you know, you think of like a creditor. Okay, if you're an LLC and you go for a loan at a bank, or you're an individual and you have an LLC, and you go for a loan, or you're going to guarantee a loan at a bank, you disclose all your assets, and the bank knows you have a Delaware LLC, should the bank be able to use it, let's say that bank is in Georgia, should the bank be able to use Georgia law to foreclose on your LLC interest if it eventually needs to do so because it calls the loan and you're in default? The bank knew that your LLC was in a different state. It knew who it was dealing with. So there's an argument there that, well, you accepted the fact that I had a Delaware LLC. You don't have any greater rights than what the creditor of a Delaware LLC would normally have. But consider the distinction if you're driving through Arkansas and you get into an accident and hurt somebody and you get sued and become subject to a huge judgment there for $20 million because your coffee flew out the window and splashed on somebody's lap and they got burned. That's a illusion. We had a second coffee case, by the way.
We did?
Second, Florida. Yeah, somebody just got $100 grand for spilling coffee on her lap going through a Starbucks drive-through. We'll maybe hit that on another one. So, you can get sued for almost anything. So you drive into another state, you hit somebody. Now that creditor wants to collect. It's maybe, you've just done damage to somebody in another state. Well, they go to collect from you, and you say, well, I don't have any assets in my name. My assets are in this LLC. I only have an interest in the LLC. And that LLC has charging order protection under, Delaware law. The interesting question is that creditor now, the injured party, limited by the internal affairs doctrine so that they can't get any greater rights than what Delaware law provides? They've never been to Delaware. They didn't pick you. And that's where I come out on maybe the other side of that, where I would say that the internal affairs doctrine applies to people inside the LLC and those who picked that state of governance. So for all of you, if you have multiple members, the members have chosen that governing jurisdiction, but third parties may not be subject to it. But Gary, I think, thinks otherwise.
We'll see.
and by the way, we'll cover a case where there's cases where that comes out, like Gary said, on both sides. So you just sort of have to follow along and know what the arguments are if it ever comes up, and understand again where you are. Florida would treat it one way, Alabama may treat it another way. So I want to talk about a couple of cases here that just demonstrate some jurisdictional issues. The first one is I believe this is from 2014, Sargent v. Al-Alsa, and this was a case that involved collection.
It was a huge collection against a foreign group.
Yeah, I think there was an Arab prince that was involved, and it was like a $40 million. It was multiple millions of dollars where they were trying to collect against this individual. And the case was in Florida, and the creditors sought to foreclose on stock owned by individuals, but the stock certificates were not here. They were in an offshore jurisdiction. And so the issue was, for the court, does the Florida court have the authority to compel the turnover of the stock certificates? And you recall that case? That's one where they stood up, actually, the asset protection, or well, not necessarily asset protection, but the fact that the certificates were not here.
Well, why don't you go into what the court had the option to do one of these turnover orders, which is kind of a civil means of saying, okay, we're going to actually put you into civil contempt and to jail until you tell whoever has these certificates to bring them back for the plaintiff who won the case. Or what we do as a court is we say, okay, you won the case, plaintiff, you have the judgment, now you have to take your judgment to the jurisdiction where the asset is, register that judgment, and collect there. There have been a number of foreign trust cases where, mostly in bankruptcy, where the court has said, look, we're going to put you in jail until you disgorge your trust assets. Now, those cases have not resulted in the beneficiary, the guy who put the money in the trust and benefits from the money, having to give up the assets. They go to jail. One went to jail for a long time, one went to jail for a short time. And they pretty much kept what they had because the assets are offshore, protected by a foreign trustee. But the alternative ruling, which you know, a lot of people were shocked at this ruling in light of the foreign trust ruling line of cases. The alternative ruling is really, it's pretty straightforward. You get your judgment in the jurisdiction where you bring suit. That doesn't mean that that court can put you in jail or even would elect to put you in jail to find assets in other jurisdictions. Other courts govern those jurisdictions. And those courts likely will accept the judgment that the court in Florida came down with. And that's what the court in Sargent said. Look, you can take the judgments, take it to Dominican Republic, where one of the stock certificate was, take it to United Arab Emirates, register it there, and collect. I don't find this one as shocking as most of the litigators, because that for years and years, that was kind of the standard format. Now the courts are much more aggressive, and yes, oftentimes will put you in jail until you disgorge. This is an appellate court decision, though, unlike a lot of the kind of fringe decisions we have to deal with. This is pretty much the law in Florida on stock certificates, I think.
Yeah, and the issue there was that the court found the stock certificates weren't representative of the asset. That is, you know, they didn't just represent ownership of the part of equity in the company, but that those stock certificates were assets. And the court said, just like any other asset, if you're going to try and seize somebody's car or equipment or anything else, you've got to go to that jurisdiction and register your judgment there. In the U.S., it's under full faith and credit. Most countries, through some treaty, will acknowledge a U.S. judgment and then go collect on it there. I was a little surprised, because there are trust cases and there's other cases where the courts have told the debtors that you need to compel the trustee to bring assets back to the jurisdiction, even though the debtor usually is the beneficiary in those situations. It doesn't have any such power. They have to go back to the trustee, tell the trustee, I need the assets. The trustee says no, because the trustee's already agreed under the trust agreement. Here, the debtor's in court, and the debtor says, well, stock's not here, you got to go overseas and get it. And the judge agreed. So it was a good decision for for debtors, and for, you know, it gives us some ideas when doing some planning for asset protection. You know, one thing to keep in mind from this case, or really the learning lesson, is you know, where the assets are matters.
What's the certificate?
You know, where are the certificates? And if those assets are offshore, you got a good chance of making a creditor go chase them offshore. If the stock was here in Florida, it'd be a different story. The other case deals more with people. So in Edwards v. Airline Support Group, this came out the same year in 2014, and in this case, there was a fraudulent transfer claim made. We've talked about those in other seminars. And so the court, or the creditor, went to court and was seeking a remedy against the transferee of property, where the transferee, or the person who received the property of the debtor, had taken it without paying reasonably equivalent value, as it was alleged. And so that third party was pulled into the lawsuit by the creditor. You know, it's similar to, you know, fraudulent transfers. I get a judgment against Joe. All of a sudden, you know, Joe doesn't have any assets because he gave his Rolex watch to his cousin, and he gave his Maserati to his brother, and so forth. And so the law prevents you from being able to do that. So you go to court, and you bring in the third party. You interplead that party into the case, or you implead them, excuse me, and you sue, and you say, you got to turn that asset over. Well, here they went after a third party who was outside of Florida, I believe in Ohio. And that party said, or Indiana, that's right, excuse me, Indiana. That party said, oh, I got it right there on the slide, in the Midwest. And they objected on jurisdictional grounds, said you can't pull me to Florida just for being a recipient of this transfer. There was a couple arguments that were raised by the creditor, but essentially they ended up winning, prevailed.
And then the answer is that you have to take your judgment,
to
sue for your fraudulent transfer in Indiana, and they have a fraudulent transfer statute, and try to get to the asset and the person in Indiana. So, you know, you can, usually these games don't work for debtors like this, pushing assets around. And in reality, legally, this won't work over time. If it's a significant amount of money and the transfer is in Indiana, you can just go to Indiana and get the asset. But it creates a lot of costs for the creditor.
Yeah, and again, it raises, you know, it just raises attention to the fact that where you know, consider when we're doing planning and we're defending, you got to consider where you're setting up your entity or your trust. Where are the assets? Where are the people in control? Here, you know, fraudulent transfer, they should, this creditor should have been able to go to Indiana to unwind it if it really was a fraudulent transfer. But, it would raise interesting choice of law issues if, for instance, let's say that the transfer occurred 3 years ago, and Florida has a 4-year statute of limitations, and Indiana only has a 2-year statute of limitations. You go to Indiana, they say, well, the statute of limitations is passed. Now you're in Indiana, but you're saying, well, Indiana has jurisdiction over this third party, but we should apply the law of Florida because that's where the claim arises. And Florida law says it's a 4-year statute of limitations. There's an example of where you would have a jurisdiction and a choice of law issue. You're up in the Indiana jurisdiction applying Florida law.
And it's harder every time you make another complexity to, like the judge in Indiana. The judge in Indiana, I think it's a hurdle. I'm not a litigator. Eric's doing the litigation. But it's always a hurdle to say, okay, now, Indiana judge, now we'd like you to apply Florida law. The assets here, we got that, the transferees here, but we don't want you to apply the law that's here. So that would be another hurdle, in my opinion. And
as another side note, I thought that the Edwards case, there seemed to be an argument that wasn't made there. And we have what's called, we still use some Latin in law, so we have personal jurisdiction or in personam jurisdiction, which is jurisdiction over a person. We have in rem jurisdiction, which is jurisdiction over property. And the argument was not made that in rem jurisdiction would apply here. And I believe in Edwards, some of the assets were in Florida. So if you have Florida assets, even if the alleged owner is outside the state, arguably if you're going after just that asset as a fraudulent transfer, you could make the argument that you would have jurisdiction, that the court would have jurisdiction over property within its jurisdiction. Again, it's something that didn't come up. You never expect all the arguments to be made or at least articulated in these cases, but it's another demonstration of all the different rabbit holes that you can go down. So we'll press on, and we're going to talk about choosing a jurisdiction. And Gary touched on this a little earlier. The protections afforded to particularly single-member LLCs depend largely upon the jurisdiction in which the LLC is formed and operates. So, typically, Gary, you do planning. You're using what, mostly Delaware,
Delaware, Nevada.
Nevada are popular.
And the South Dakota is pretty good.
Yeah, you don't have this issue as much with a multi-member, and so when you're looking at multi-member, oftentimes you're best off in your own state. But
and there's a distinction that you should keep in mind when you start shopping these jurisdictions. Foreclosure of the charging order can mean two different things. Once you try to sue someone, they have an LLC, you want the LLC interest, you get a charging order in general, unless you're in one of these weak single-member jurisdictions, you can just actually foreclose the equity in the LLC. Now, if you get a charging order and you can foreclose it, you don't get the equity in general. You just get instead of a lien, you get a actual saleable charging order. What that means is you have this lien that doesn't expire, you foreclose it out, and when you foreclose it out, you own the charging order outright. You could sell it. Does that matter? Maybe. If in fact you foreclose out a charging order in a valuable real estate partnership, it would matter. If it's dealing with an active business where distributions may be directed away from you, it's probably not that significant.
So, by the way, we have a written outline that has the material that's in the slides, and maybe in a little bit more detail. I'm going to drop that into the box before the end of the webinar, so you'll be able to pull that out. We'll also make those materials available on our LinkedIn group. So if you have not joined our LinkedIn group, please do so. We'll have links to the webinar recordings as well as outlines and seminar materials and articles that we've done to cover these topics as they arise. So I'm not going to talk too much about the Uniform Limited Liability Company Act. It's kind of boring compared to some of the other stuff.
It's just a guidepost. The jurisdictions that have adopted this Uniform Act, there's a group that puts out these uniformed acts for the states to adopt. This would represent some of the weaker statutes. I think in the outline we mentioned some of the actual states that have adopted this. some have adopted partially, some not, and this would be the statute that allows generally for foreclosure of a charging order.
And so where the act has not been adopted, there is probably no right of foreclosure because the right of foreclosure with respect to LLC interest is a relatively new phenomenon. But if there's no specific language dealing with foreclosure of LLC interests, you want to be wary of that, because up until 2000, when was Albright? 2003, there hadn't been foreclosure of an LLC interest, but a bankruptcy court allowed foreclosure of a single-member LLC in Colorado in the In re Albright case in 2000.
That was the Colorado issue where they brought up the idea of not having a partner.
No innocent partner explanation, right? We've talked about that one before, and in Florida, of course, I think that was big news. Florida Supreme Court, in a question that was certified by the 11th Federal Circuit, allowed foreclosure of a single-member LLC. Usually,
they actually completely allowed anything to be foreclosed, kind of equating the LLC to a corporation. So the whole statute had to be rewritten.
And so, and keep in mind too, some of these, oftentimes the facts in these cases can sway the result. And so, if you're a litigator, you're picking, do I have good facts that I want to run to try and make law? The Olmstead case in Florida was the FTC suing some alleged crooks for some credit card scam where they had allegedly built some people out of $4+ million and put it into an LLC.
It was a terrible actor. He used single-member LLC, so they wanted to reach the equity to pay back the FTC and the victims.
So, here's just a pointer. If anybody out there, if you're considering whether to form an LLC, particularly a single member in a particular state, if the statute is silent on foreclosure, don't assume that it doesn't allow foreclosure rights, because somebody's going to argue that the statute doesn't prohibit foreclosure. So the language you want to see, and I know this is in, I used to practice, I'm licensed in Nevada, I know Nevada has language that says no foreclosure of single member LLCs at all. I think Delaware is.
It says there is. It's the exclusive remedy is the charging order, and foreclosure is prohibited, and that includes the single-member LLC.
And Florida, meanwhile, precludes foreclosure of multi-member, but where there's a single member, it's allowed if you can make a showing that you won't reasonably have an opportunity to collect just through the charging order itself. So statutory language and interpretation is important there. So what about trusts? So we have this issue with self-settled trusts that gain popularity, and they've been, in the recent years, been something that people look at for asset protection. We have domestic self-settled trusts or domestic asset protection trusts, and we also have ones that are formed offshore. Gary does both of them, and the offshores are more ironclad and a little more complicated, but safer. Onshore, you've got 18 states at last count, or excuse me, 16 states that allow them.
Yeah, well, you have to realize that the trust, the historic trust, could not be organized in a protective way unless it was for somebody else. So Dad could do it for son, and then appoint a trustee. And if anyone ever sued son, the assets are not available. So this went on for 300-400 years. And in the Caribbean in the late 80s, some of the island nations started to say, well, you can form a trust for yourself, and it's still protected. And a lot of money went into those jurisdictions. So a few states said, well, why don't we just allow that? And now we have 16 states that allow that. The difference is that, depending on where the judgment is, it's in the states. So some courts, seems like some courts are going to respect the domestic self-settled trust, and some courts may not respect it. We've got a couple cases here coming up to give you some guideposts of what will be respected. But those issues of which state is going to respect what and where the assets have to be in some cases kind of go away if we use a foreign trust. We have trusts outside the country, assets outside the country, the trustees outside the country. The court just doesn't have jurisdiction over anything. So I guess we can get into some of the detail.
The choice of law issue is, how will a state that doesn't have a self-settled trust statute treat a self-settled trust from another state or from offshore? And so, an example, a good case that sort of brings out the issues that we're looking at is this In re Huber case. This was a Washington bankruptcy court where the debtor had formed an Alaska trust, and Alaska was the first that state, correct?
Yeah, Alaska was first. Yeah.
So Alaska has a domestic asset protection trust statute. They allow the formation of trust, and a debtor and an individual in Washington says, well, I'm going to take advantage of that and create a trust in Alaska to be governed by Alaska law or under Alaska statutes, and put all of his assets into
but under somewhat questionable circumstances. He was, a developer. He was running into problems, so it created these facts that we talk about that result in litigation and a nice scream out, so that we can get an opinion that gives us some guidance.
And so here's some of the stuff that he did. So he put essentially all of his assets in this Alaska trust, including land and developments that he had in Washington.
Not in Alaska, right?
Vehicles that were in Washington. Then he made himself in Washington the beneficiary, and he had two trustees. One was in Alaska, and the other one was in Washington, his son. So he had very little connection to Alaska. Almost everything was in Washington. And the argument that the trustee made to get to the assets was, they said they made a choice of law argument, and the trustee said, well, everything's in Washington. This guy's really got no connection to Alaska other than the fact that he picked Alaska to form this trust. And because it's in Washington, we can use Washington law, and Washington law finds as a public policy self-settled trusts, the concept of self-settled trusts, to be something that we don't want to adopt. So they didn't have a law for self-settled trusts, and they had a strong public policy against self-settled trusts. And that was ultimately the argument they made. They said everything's here, the assets are here, the trustee's here, and so we should be able to treat it as a Washington trust. And if it's a Washington self-settled trust, it's not recognized, and so it's really just we can look through it and treat it as nothing. Essentially, ignore the trust, treat it as an alter ego of the debtor. It's just an alias of the debtor. And the argument was successful. So now, what could Mr. Huber have done to help protect himself and make that stand up? And let me add, by the way, in that case, it appears that the trustee from Alaska was sued and almost immediately folded. So they didn't want anything to do with they didn't want anything to do with the litigation. So so there's lessons from Huber. What are the lessons that we take out of it? From that. And Gary, maybe you want to talk about what you want to do.
We want to create more of a connection to the jurisdiction of the trust. So there's two levels. One is we'd like the trust to be enforceable in the home jurisdiction. So if Huber and DC had put only, Alaska banking and brokerage accounts and property into the Alaska trust, appointed an Alaska trustee only, he could appoint a protector as well. A protector is someone that is like a veto power on distributions to make sure that the trustee doesn't steal money. But in any case, most of those people, if not all, should be in Alaska. So you create kind of a connection to the jurisdiction. That's one thing, to actually deal with a court in another state not respecting the trust. Probably would have been successful on that. The other side is one that Eric brings up a lot. We don't look at it that much as planners, but it's an interesting concept, and that is, if I'm in Florida, for instance, even if I don't feel that a Florida court will uphold my Nevada or my Alaska trust, if my assets in the trust are in Nevada, okay, and my trustee is in Nevada even though I'm here, if a court says, no, we're going to look through your trust and we want those assets, and I say, well, the assets are in Nevada and the trustee's in Nevada, the trustee's going to get sued right? Based on the judgment in Florida that there is no trust, he's going to dispute it. Where does that case have to take place on the collection of those assets? It's likely Nevada because the assets are in Nevada and the trustees in Nevada. Now we've shifted the perspective to a Nevada court who may have a different opinion about the trust. And that creates a lot of time and expense for the plaintiff creditor. So in any case, when we do these domestic asset protection trusts, we want to create the connection either just to create legal, for the court to legally respect the trust, and then practically we want to make the person, whoever's trying to get those assets, go back to that jurisdiction and fight a judge in that jurisdiction for collection. The offshore stuff is completely different. I mean, we don't want to leave any assets in the States, and we want to have an offshore trustee, but it's very different because the offshore trust is governed by law that's offshore, and the court is offshore, and the jurisdiction of the U.S. court, they just don't have any power over those assets. That's why they're so powerful. Eric just pulled up the next slide, which is the Rush University. The classic mistake with doing these foreign trusts is for them to hold property here. A lot of lawyers will say, well, no, I'll just hold the property here, and if I get sued, I'll move the property. It's not so easy to move. I think this was real estate, to move real estate inside of Cook Islands Trust. I think this was a crazy case because this case was it was like a charitable remainder case where a very wealthy person pledged to give these assets to Rush University Hospital, which is in the middle of Chicago there. And then when he died, the estate reneged. Did you know that?
Yeah.
They reneged, so they sued him.
I think there was an issue. He blamed, I think, the hospital for. I think he died. He died
at
early,
the hospital.
And I think there was some blame put on the hospital. So then he reneged. He all of a sudden they didn't want to turn the money over that he promised, and he got his name on the building. So he pledged money to the hospital. Yeah. They named the building after him, and because I thought, well, if it's a gift, you've got issues to consider. You've got all these just standard contract issues, but he had it named after him, and
so there's a line of cases. This is kind of the end of the line of cases on foreign trust that basically say, well, what we're going to do is, because you're here and the assets here, is we're not going to apply the law of the jurisdiction of the trust, which of course is a huge jump. In bankruptcy court, it was easier to get away with that because the bankruptcy judges basically are unbounded by, this public policy stuff. But in this case, they filed the bankruptcy case and said, no, we're just going to treat it like it's an Illinois trust and disregard it completely, and so we're going to give the property to Rush University. It's just, we've gotten to the point, I think, where if we're going to do these foreign trusts, we have to have the assets offshore. The local financial planners oftentimes aren't that happy with it because a lot of the wirehouse cannot accommodate offshore assets. But at least for a portion of a very wealthy person's assets, it's really a very good idea, honestly.
And so, by the way, we had a couple questions. I did drop into the sharing box the outline for today's presentation. A few people have sent us questions asking if slides will be available. If you'd like a printout of the slides, please shoot an email after the session, and I'll make sure you get a copy of those. But the outline has all of the material plus more that's in the slides. So actually some of the things that we talk about that aren't on the slides will be in the outline, and that provides more detail. We'll provide that as well on our LinkedIn group, and we'll put the slides on there as well.
Okay.
And somebody asked about CPE credit for accountants. Yes, we do keep the list. And if you send one of us an email or send an email to the info@fbl-law.com email address, again, it's fbl-law.com, we'll make sure you get the information that you need, the signed card for the CPE credit. And by the way, while I'm just on that topic, please connect with us on LinkedIn. We drop new articles and materials on there. We have our page on LinkedIn. And we welcome questions during the webinar or after, by phone or by email. So Gary's kind of hit on some of these issues. Moving back into the slides here. on the keys to effectiveness for trusts. I think we can take the lessons of Huber and the lessons from Sessions and what Gary said. And basically, you want to make sure that you have a connection with the jurisdiction where the trust is formed, and keep as little of the assets or trustee, anybody who can be drug into the jurisdiction where a creditor might be sued. You want to keep those folks in a different jurisdiction. And also you have a note here that, especially on the accounting side, if you do an offshore, Gary does the offshore trust, but there may be specific reporting requirements for those.
There are. It's not bad.
And then other topics on jurisdiction. We'll just hit a couple more things here before we just open up for questions. Wyoming was a place where they were one of the first jurisdictions to specifically preclude foreclosure of single-member LLCs and became a favored jurisdiction.
It's the first LLC.
The first LLC jurisdiction. So Wyoming, and sometimes these states do this, they generate business because they generate, revenues from people registering there. But then all of a sudden this case comes out of nowhere, this Green Hunter case, and they didn't allow foreclosure of the LLC interest. It actually was the other way. We have a regular concept of piercing the corporate veil, and that's where you try to look through a company's obligations to get to the individual. So people traditionally would form a corporation or an LLC because they're doing business, and if that corporation becomes subject to a judgment or a claim, unless somebody has personally guaranteed it, the claim is insulated within the jurisdiction of the LLC. Well, in this Green Hunter case, the debtor had actually was a subsidiary of the debtor who did business and became liable for a debt, and the court allowed the creditor to pierce the corporate veil and look through the subsidiary's corporate protections and get to the parent company.
But they had mentioned as a factor, which was crazy,
very crazy,
the fact that the subsidiary was disregarded for tax purposes, which is really unrelated to corporate protections. So, the scales tipped. We loved Wyoming, and we loved it for the single member, and we were doing 10 Wyoming LLCs a month, and then we went, nope, that's the end of that. And so now it's Nevada and Delaware, because you can't really have that kind of instability.
The business climate in Wyoming has to hate this decision.
Yeah.
And so it really, it caused a mass exodus from Wyoming planning. It's just another example of one of these crazy cases. There was no reason that really shouldn't have been sufficient to allow piercing a corporate veil, in my view. To get to the parent company through a subsidiary. Several jurisdictions, including Florida, require some showing of really using an entity for fraudulent conduct in order to pierce the veil. Delaware isn't quite as stringent, but it's still a high standard. And so, it's just another one of these issues that, where the law of a certain jurisdiction, had that entity been somewhere else, it may have been a different story. And we talked there about Green Hunter. So, offshore options, Gary, since you do some of these trusts, you want to talk about, the offshore options for trusts and LLCs?
Well, the trust we've talked about, it's very, very difficult to get to a trust if the assets are offshore because there's no jurisdiction over the trustee. There's statutory protections as well associated with distributions and protectors. A lot of that has been adopted by the 16 states in the U.S. The key is that there's no way to legally reach the stuff offshore. This mentions the LLCs. The LLC, when you have a free hand to create a fraudulent transfer act, I just created the most onerous possible debtor-friendly expiring fraudulent transfer act, expiring charging order. Basically, it's very hard to claim fraudulent transfer for transfer into a Nevis LLC if you're in a Nevis court. So you'd be in a Nevis court if the assets are offshore. So it's a very, very protective LLC. A good structure is to actually create the offshore LLC, and then for your investments, for the trust investments, hold those in the Nevis LLC. It's hard to get a lot more protective than that. We should wrap up because we don't want to hold you too late. Are there any more questions?
Yeah, it's about 10 till, so we've gone almost 50 minutes here. We'll take questions if anybody has any. We have a few extra slides, and like I said, all the materials and the material that we provided. Let's talk about one more, if we don't get a question here.
Okay.
Let's see. You want to talk about one more case? Talk about Barber? That's a good.
Oh, that's a good case, yeah.
So let's talk about, this is an LLC case, and a couple mistakes made here. So Sabrina Barber gets sued by Wells Fargo. I think she had storage units, and they went into default when real estate crashed and became subject to a big judgment. And she had a homestead property in Florida, which would have been exempt from creditors. Arguably, you could take an exempt asset and convert it into something else. So maybe she would have sold that homestead and immediately put the money into either another homestead or just moved it somewhere outside the jurisdiction into some other, maybe into a trust for her kids and herself or something of that nature. But in any event, she had the homestead. She sells the property, takes the money, and then it moves a couple times. This again where these cases get weird. So the money moves from one account into another account into another account, and it ends up in a bank account that's owned by a Nevis LLC. So Gary does the Nevis LLC.
Not this one.
Yeah, not this one. Very effective for protecting specific assets. But this is an example of what, how not to use a Nevis LLC. So she puts, and I think she had the money.
So what Eric's trying to say, so it's a lot of steps. What Eric's trying to say is you have your Florida homestead, which is protected almost no matter what. And then if you sell the homestead, the assets remain protected in a segregated account. So basically you're segregating the assets to invest in another homestead. The last thing you want to do is like muddy the water, because those are your clearly protected funds, even if you're being sued. She muddies the water completely and brings in a foreign LLC. At the same time, all the accounts are in Florida.
All the accounts are in Florida, owned by the foreign LLC.
And she owes like $28 million or something.
And so the creditor goes to court and says, well, we want to foreclose on her single member interest that owns these bank accounts. And of course, her attorneys defend and say this is a Nevis LLC. Nevis does not allow foreclosure of a single member LLC, internal affairs doctrine, etc. You have to go to Nevis, or you have to apply Nevis law, which limits you to a charging order. And the court essentially says, no, you're here in Florida. And now distinguish this from the earlier case we talked about, Sargent, with stock certificates. Here you have it uncertificated, no certificates for the LLC, and the court says your ownership of the LLC is a intangible asset that is here with you, the person. And the judge says, you're in my court, the asset's in my court. I'm going to apply the local law, which is Florida law, which allows foreclosure
of a single member
LLC if it seems reasonable that they won't collect. I don't think that they have any chance in the near future of collecting on their $61 million judgment or whatever it was.
Well, there won't be any distributions.
Yeah. And so the judge allows foreclosure of the LLC interest under Florida law, and it was a Nevis LLC. Classic example of what not to do. And there's a question, I'll bring the question, but I want to point this out. This is where you get really cute, and we'll talk about this maybe in another seminar. Had she had assets from Nevis, it would have been much tougher. You could have said, well, we're going to foreclose, but then you'd have to go back after the assets. But having the assets here in Florida, that's where you really get a problem, because now we're applying Florida law, and it's very easy for the creditor to then take that judgment and seize the assets here in Florida. So here's a question that we have popped up. We're happy that we got one. Maybe we'll get some more. The question is, as a non-attorney, where should I, as a Pennsylvania resident, form my LLC? Seems the added cost for a Delaware LLC is not worth the added protection versus a Pennsylvania LLC. I grew up in Pennsylvania, Philadelphia area, so hello out there. And Gary, what would you say? It depends on the statutory language.
Well, we don't use Pennsylvania. I think that's a uniform act state. We could probably check it at some point. It's if you're using it for your business, it's not probably going to be that significant unless it's a single member LLC. If you're using it for investment, I wouldn't use the Pennsylvania. I'd use the most protective jurisdiction. What it boils down to is, even if for some reason you don't get the protections because you're in Pennsylvania, your assets are in Pennsylvania, you probably my impression is on those cases you probably will get some, if not all, those protections. But even if you don't, why not use the better jurisdiction? I mean, take a shot at using the better jurisdiction, at least for your investment assets. I would absolutely recommend that.
And let's see. Could you give us the link to LinkedIn? Oops, I missed that. Okay.
Oh yeah.
And
it's on the announcement.
yeah, the link, the announcement that you got for today's webinar contains that link, and we can circulate that afterwards. If for some reason you don't get that, please email Gary or I, or email info, and we will make sure you get the LinkedIn link. And then I think we've addressed the Pennsylvania question. We're just looking to see if there's any more questions. All right, I don't think we have anything else. And with that, unless something else pops up, if you think of something after the webinar, please don't hesitate to, again, shoot one of us an email, or both of us, or give us a call, 407-255-2055, and we will be happy to speak with you. Have a great rest of your day. Thank you very much. Bye-bye.